You will probably have seen in the news that there's now calls for a public inquiry into what I'm going to call CSE, that's child something exploitation, also sometimes child something abuse. The thing to remember though is there's already been an inquiry. That was conducted by Professor Alexis Jay. It actually reported all its findings in October 2022, and it made a series of recommendations. So what I thought I'd do is just briefly explain how that inquiry came about, what they actually found, and what recommendations they made, and also to what extent those recommendations have been implemented. Now, I can cut to the chase and say so far none of them have been. Neither the previous government nor this government have actually implemented any of the recommendations. I don't want to get into the politics of this because I just want to come at this from a sort of like legal perspective. I mean, so the first thing is, like I said, this was a statutory inquiry. It was led by Professor Jay, but she had the help of a number of people. And it's actually a very comprehensive inquiry. There were actually 325 days of public hearings. They processed over 2 million pages of evidence, and they heard from 725 witnesses. The inquiry's also published 61 reports and publications. Over 7,300 victims and survivors engaged with the inquiry. As I said, more than 700 gave evidence at the hearings or provided statements. Over 6,200 people came forward to share their experiences with something called the Truth Project, which allowed people to come forward and sort of tell their stories. And nearly 1,800 people joined the inquiry's Victims and Survivors forum. So what did they actually found? Well, like I said, this inquiry lasted for 7 years. And so the work of the inquiry over the past 7 years demonstrates that CSA and exploitation takes many forms, but can involve vile and painful acts. And they do go on to describe those, which I won't, because, the YouTube algorithm, and also, you can imagine yourselves. Children, particularly those who were sexually exploited, are often degraded and abused by multiple perpetrators. Historically, inadequate measures were in place to protect the children from the risk of being abused. Sometimes there were just none at all. This is the next one, and I think this is one of the biggest problems. Individuals and institutions often thought that children were lying when they tried to disclose what was being done to them. Victims were frequently blamed as being responsible for their own sexual abuse. Within statutory agencies with direct responsibility for child protection, there was too little emphasis on the complex and highly skilled work of child protection. Decisions about children were not unequivocally based on the paramount interests of the child. I mean, that's a general thing in law when it comes to looking after children. The welfare of the child is paramount. You see this in family proceedings. People go, well, we're parents, we have our rights. Actually, you don't really have any substantive rights. You have rights to be sort of like heard and, give your side of things. But fundamentally, the only thing that matters as a matter of law is the actual welfare of the child. They say multi-agency arrangements still lack focus on child protection. There's not enough support available to both child and adult victims and survivors. This isn't something that's historic and confined to the past. And they're saying, this is still endemic within England and Wales. The devastation and harm caused by this sort of thing, it can't be overstated. The impact of CSA, often lifelong, is such that everyone should do all they can to protect children. And, as I say, this isn't just a national crisis. It's a global one. So that's what they actually found. I mean, like I said, the report itself, and I'll put the link in the description before, because I think it's well worth reading the full report. And that's what I did, because I'll be honest with you, I mean, I didn't even know about this. Now, this isn't an area I know a lot about anyway. But with all this, there's a lot of misinformation out there. So what I thought I'll do is, I delve into this to have a look, because people said, well, there's been this inquiry. So it's like, really? Well, I didn't know anything about it, but I've read through the report. It's, I don't want to say fascinating reading, but it's grimly fascinating. It's also highly depressing. But anyway, they've made a series of recommendations. And like I say, none of these have been implemented. But I'll go through what the recommendations are. And you can sort of like decide for yourselves, and feel free to comment on whether you think they're actually adequate, or do they need to go further. But recommendation 1, they said actually they need a single core data set. And they said, the UK government and the Welsh government, I won't keep repeating the Welsh government because this report applies to England and Wales specifically. And obviously some of the recommendations, some would be for sort of, the Westminster government, and some would be for the Welsh government. But they said they should improve data collected by children's social care, the criminal justice agencies, about what's been going on. And there should be one single data set covering both England and Wales. Because, unless you know the extent of the problem, how do you go around addressing it? And they said data should be consistent, and it should include characteristics of the victims and the alleged abusers, such as age, sex and ethnicity. It should include factors that make victims more vulnerable to this sort of thing. It should say where the exploitation happened and the context in which it happened. And they said the data should be compiled and published regularly, and should be capable of being organised at national, regional and local levels. Recommendation 2, this was to prioritise the protection of children. They said there should be child protection authorities for England and for Wales. The UK government should create a child protection authority for England, and the Welsh government should create a child protection authority for Wales. And each authority's purpose should be to improve practice in child protection, advise and make recommendations to government to improve child protection, and inspect institutions and settings as it thinks is appropriate. And also that the authorities should monitor the implementation of the inquiry's recommendations. So the idea is set something up. Here's what we're recommending. Set something up, monitor this, and report back on whether you're actually, complying with anything about this and what's actually being done. Also, recommendation 3, they said there should be a cabinet minister specifically for children. Recommendation 4, public awareness. The UK government should commission regular campaigns to increase public awareness of CSA. These should say what to do if CSA is happened or suspected. So the campaign should challenge myths and stereotypes about CSA. This could include different approaches such as public information campaigns and creative media such as television and drama. They then move on to sort of empowering the children and young people themselves. Recommendation 5, that was to do with something called pain compliance. Because like I said, they looked at everything in this inquiry. They spent 7 years, they looked at schools, care homes, institutions, hospitals, families and everything. And they actually said one of the things that they came back was they said that the UK government should ban the use of any technique that deliberately induces pain. These are sometimes referred to as pain compliance techniques. The UK government should withdraw any policies that allow pain compliance techniques to be used in custodial institutions where children are detained, and should prohibit the practice. And they point out actually that this is a recommendation that's been made many times in the past, but nobody's ever done anything about it. Obviously that's not to do with sexual abuse, but they're saying it's still a form of abuse. The irony is that in sort of, adult prisons, generally speaking, you can't use torture to, force compliance, but you can in children's institutions. Recommendation 6, that's to do with the Children's Act 1989. The UK government should amend the Children's Act 1989 so that looked after children, that's what we used to call children in care, or someone acting for them can apply to the family courts for orders to mandate or limit local authorities' exercise of its parental responsibility. If a child in the care of a local authority is or believed to be suffering significant harm or is at risk of significant harm, it would allow the court to stop a local authority taking or planning particular action, or allow the court to give directions in relation to the local authority's exercise of parental responsibility for that child. Because obviously where you've got looked after children, the local authority effectively is acting in loco parentis. But what they're saying is, well, in the same way that the local authority could bring proceedings against parents or guardians if they thought they were, abusing children or allowing the children to be abused or just otherwise not looking after them, they're saying get your own house in order. So people should be able to bring proceedings against the local authority, saying, you're not sort of doing this. And then the courts could step in, at least they'd have a supervisory role. But more importantly, they could make orders and directions saying either stop doing that or you need to do this. Creating a more protective environment for children. Recommendation 7, registration of care staff in children's home. The UK government should introduce a system for registering staff working in care roles in children's homes, including secure children's homes. And again, they point out that this has been recommended before and nobody's ever done anything about it. Registration should be with an independent body. This body should set and maintain standards of training, conduct and continuing professional development. It should have the power to enforce these through fitness to practice procedures. I mean, you might find it surprising that anybody can go work in a children's home or a secure children's home without any sort of qualifications, references or indeed background checks. Recommendation 8, registration of staff in care roles in young offenders institutions and secure training centres. And say the government just introduce, as above, a system for registering the actual people who actually work there. Recommendation 9, greater use of the barred list. The government should enable anyone who hires people to work or volunteer with children on a frequent basis to check if they've been barred by the DBS. That's the Disclosure and Barring Service. And this should also apply even if the role's supervised. So you can't just say, well, we've got somebody there who's, been DBS checked, but everybody working under them, it's just a bit of a free-for-all. Saying, no, everybody who has contact with children should go through this vetting procedure. Recommendation 10, improving compliance with the statutory duty to notify the DBS, Disclosure and Banning Service. The UK government should take steps to improve compliance with the duty to notify the DBS service. The National Police Chiefs Council should work with regulators and inspectorates to make sure that the arrangements are clear for referring breaches of duty to the police. And the DBS and the regulators and inspectorates should put in place an information sharing protocol. So what they're saying there is if you do identify somebody who is dodgy or somebody who's not doing something correctly, then you should be allowed to notify the DBS service and say, hey, this is what's going on with this person, so they can at least note it. And that also different people should share information. Because, you might get somebody working with children who does something, they might get sacked, but there's nothing to stop them just moving to a different area and just getting a job there because the information just wasn't passed on that, this person is not somebody who can be trusted with children. Recommendation 11, extending disclosure regime to those working with children overseas. The UK government should enable the DBS service to provide enhanced certificates, and including with barred list checks, for those who are not allowed to work with children and, to cover people working abroad. Because that's the other thing, you might get sort of caught doing something nefarious over here, but there's nothing to stop you just sort of like, moving abroad. I mean, it's slightly different now post-Brexit that you can't move around quite as much. But, currently it's just like, oh, well, I've been rumbled in the UK. I'll just go set myself up somewhere else. Then move on to identifying and reporting CSA. Recommendation 12, pre-screening. The UK government should require regulated providers of internet search services and user-to-user services to pre-screen for known CSA before material is uploaded. So that's just sort of, this overlaps a little bit with the online safety bill, but it's all about regulating things on the internet. Recommendation 13, mandatory reporting. Just saying, just introduce laws that if people see something suspect, they should be obliged to actually report it. Currently there isn't anything like that. I mean, it's interesting just to compare to, the Bar Standards Board, the regulation of barristers. It's actually a disciplinary offence for us not to report bad behaviour amongst other barristers. If we see something or even hear about something, we are supposed to report it. Now, interestingly, there is a slight exception to that, because it used to be that if we did become aware of, say, harassment, especially sexual harassment of people, it's like, well, we've got to report this. But after much sort of going back and forward with the BSB, because a few of us did write about this and say, look, it's not really, it has to be up to the victim. Because, if they know we've got to report, because I get this, I work a lot with the sort of new barristers and people, and we chat and stuff, and I'd like to think I'm approachable. Also, I wear a little badge that basically alerts people to know. It's called All Rise, and it alerts people to know that actually you can come and talk to me if you're being bullied by another barrister, somebody in chambers, even the judiciary. Come and talk to me. At worst, it's a sympathetic ear, but it might be that I can have a word with, the right people. But the danger there it's like, well, have you got to tell people? Because, I don't want to ruin my career. I don't want to be seen as a troublemaker. So now we have changed that, and it's up to the victim what they want to happen. And they can say, look, I just want to tell you this, but please don't tell the BSB. But there's nothing analogous to that for dealing with CSA, with like local authorities or schools or institutions or anything. And we move on to the justice system. Justice system responds to CSA. Recommendation 14, compliance with the Victims Code. The UK government should arrange for a joint inspection of compliance with the Victims Code in relation to victims and survivors of CSA. The Victims Code sets out a minimal level of service to be provided by the criminal justice system. And they point out again, this has all been recommended before and nothing's ever been done about it. But the idea there's meant to be this Victims Code, but is it actually being followed? I mean, you hear all sorts of horrible stories about, people, reporting things. And we've seen these stories about, going to the police and the police saying, well, you were asking for it, or you were drunk, or you're not really a victim, or we're going to nick you instead. Recommendation 15, limitation. They should change and remove the time limit for victims and survivors of CSA to make legal claim for compensation. These provisions should apply whether or not the current 3-year period has already started to run or has expired, except where, it's already been dealt with. The right to a fair trial should be expressly protected, but these changes should not apply to claims brought on behalf of the states of victims. But what they're saying there is, a lot of the time people are going, yeah, this happened to me, a long time ago. I'd like to bring civil proceedings, but I am now time barred. I mean, if you were under 18 at the time, then the time starts running from when you are 18, and there's some later recommendations that do cover that slightly. But what they're saying now is often people are just scared to come forward, or they're not in a position to, especially, a lot of these kids were, in care. And, when they're suddenly booted out of care, as they reach, quotes, adulthood, they'll probably got other priorities in just trying to survive and trying to establish themselves and just trying to, get a roof over their head and food to eat. This might not have been a priority, however horrible it was. But what they're saying is, and also they might have just been going, I'm keeping my head down. I'm not going to be the only person to report this. But then it might be, as we often see, somebody comes forward and then lots of other people go, actually, yeah, this was also happening to me. So to be able to accommodate that, get rid of or at least extend the limitation period, or make it easier to waive limitation. Recommendation 16, specialist therapeutic support for victims, for child victims. The UK government should guarantee that all child victims of sexual abuse will be offered specialist and accredited therapeutic support, and that they should be able to access it. And also, that it's not just a little short-term thing, that it's for as long as they need. Because there was a thing where people were offering therapy, and it's like, well, you can have one counselling session, but then that's your lot. Recommendation 17, access to records. The UK government should direct the Information Commissioner's Office to introduce a code of practice on keeping and accessing records which relate to CSA. The code should require records about CSA and allegations of child CSA to be kept for 75 years with appropriate review periods. Because that's another thing, people are going, you see a lot of this like historic abuse. And then it's like, well, this was all going on at a particular care home, or even it's just a case of this was going on in the community and we reported it to council, but it's like, we need to investigate, we've got rid of all our records, we don't keep them for that long, we don't have the space to keep everything, so I'm afraid all those records have gone. Say, well, no, now you've got to keep them for 75 years. And finally, making amends. Recommendation 18, the Criminal Injuries Compensation Scheme. I mean, I've done video on this, and I might do, if there's a demand, I'll do another one. But that's a system where if you've been the victim of a crime, then you can actually claim for compensation through the Criminal Injuries Compensation Scheme. But what they said is it should be expanded to include other forms of CSA, including sort of online facilitated stuff, like grooming and all that sort of thing. Also, that victims and survivors with unspent convictions should not automatically be excluded, especially where the crimes are likely to be linked to the abuse they experienced as a child. Because at the moment, you can't, generally speaking, claim under the Criminal Injuries Compensation Scheme if you yourself have a record. But as we've seen here, a lot of the children, they were themselves prosecuted. It's like, oh, well, we're going to, we've turned up at a house and there's, a semi-naked child here and loads of guys. We'll nick, and she's off her head on like drink and drugs. We'll nick her, for sort of like being, drunk and disorderly. That would actually exclude somebody from bringing a claim. And again, what they've also said is that the time limit to claim compensation should be increased to 7 years. And that period should run from the date of the offence, the date the offence was reported to the police, or from the date that the person reached the age of 18, where the offence was reported while the victim was a child. And also that in all circumstances, there should be a discretion to extend the time limit. Recommendation 19, a redress scheme. The UK government should set up a single redress scheme for victims and survivors. The rules for this should reflect the following key points. That the scheme should be for victims and survivors of CSA, including abuse from other children. There should be a clear connection between CSA and institutions in England and Wales, whether state or non-state. The scheme should apply to CSA that took place before its establishment and should be open for a period of 5 years. There will be a sort of thing in there saying not to double recover. So if, for instance, you'd brought civil proceedings or you'd done something through the criminal injuries compensation, then you can't get it twice. The scheme should make payments through a two-tier system. Firstly, you just get like a flat fixed rate recognition payment. Yeah, this happened to you. But then also, there may be like the equivalent of special damages. So there could be a second payment if you can actually sort of go into more detail and provide more evidence of how this affected you. The process must be accessible, straightforward and sensitive to the needs and vulnerabilities of victims and survivors. And that central and local government should fund the scheme. And they said England and Wales might have to sort out the financing separately. But the idea here is that, a bit like the post office really, where it's like, look, rather than go through all the civil procedures and all the different ways, let's just have one, a one-stop shop, one port of call. We can go, right, this happened to me. Can you do something about it? Rather than necessarily have to sue in the civil courts or have to bring a claim for criminal injuries compensation. Just a sort of place where you can go along and say, right, this happened to me. And say, okay, we accept, here's your initial sort of fixed fee payment because we accept something happened to you. But also then, if you want to provide more detail, then we can look into it and perhaps top up that compensation on a case-by-case basis. And then finally, recommendation 20, age verification. Just saying that they should change the law to make sure that internet companies provide online internet services, that provide services, and social media should have better ways of checking children's ages. Because we all know kids can get online fairly easily, and it doesn't matter if you say, oh, you've got to be 13 to use this or 16 to use this. There's no actual way of enforcing that. And part of the problem is, especially with grooming offences, they do take place, a lot of them take place online. I mean, kids spend a lot of time online now, and unfortunately, there are a lot of predators out there who take advantage of all that. So there you go. So yeah, that's a very, very brief overview. Like I say, I will link to the actual full report. And like I say, I don't want to get into the politics of all this. I just want to look at the legal side of it. And, inquiries, it's a legal thing. But, we've seen discussions that there may be a future inquiry or people are wanting further inquiries. But, what do you think? I mean, it seems to me this is a very comprehensive report that wouldn't just cover the sort of gangs that we're talking about and the fact that social services may have let people down or local councils may have ignored the kids or, the police were very dismissive and just arrest the children rather than the perpetrators. That's all covered in this, but it seems to me that this goes actually even further. It's a very holistic approach to just abuse generally, and not just estual abuse, just abuse generally. But of course, the problem is, unless anybody actually implements any of these recommendations, what was the point of it? Like I say, 7-year inquiry, nearly literally a year's worth of actual people giving evidence and millions of pages, and speaking to, thousands and thousands of victims about this, and just, people involved generally. So it does seem it was a very comprehensive inquiry, and it does seem to me that a lot of those recommendations do make sense. But like I say, if they're not going to be implemented, what was the point? Oh well, there you go. As always, hope you found that vaguely useful, vaguely informative, possibly wildly infuriating. And just let me know your thoughts in the comments. I mean, like I said, I'd like to, I will get back onto just general sort of, arty law stuff, but it just seemed appropriate while everybody was talking about all this to just sort of go, you do know there's actually already been an inquiry, because that seems to be something that slipped under the radar a little bit.